we will open up the hearing on House Bill 1056. Staff report.
Good almost afternoon, representatives. For the record, John Brzezinski, staff to the committee. House Bill 1056 relates to the authority of the Attorney General to address local law enforcement and local corrections agency misconduct through investigations and legal actions. Chair Taylor, there is a proposed substitute by Representative Farivar on the EBB. Would you like me to brief the proposed sub?
Please brief.
As background, federal law prohibits governments from engaging in a pattern or practice of conduct by law enforcement officers that violates a right, privilege, or immunity under the United States Constitution or federal law. When the United States Attorney General has reasonable cause to believe such a pattern or practice exists, the Attorney General may bring a civil action to eliminate the pattern or practice. Washington law does not currently contain a direct parallel. However, state statute and case law have established the Washington Attorney General may act in any court, state or federal, trial or appellate, on a matter of public concern, provided that there is a cognizable common law or statutory cause of action. House Bill 1056 expressly authorizes the Attorney General to investigate and bring legal actions against a local law enforcement agency or local corrections agency for a violation of the state constitution or state law. The bill's intent section specifies the Act's state-level authority is not intended to hold individual officers liable for misconduct. The bill provides the Attorney General may, 1, investigate violations on its own initiative or in response to investigations or reports from independent oversight bodies, 2, issue written civil investigation demands for documents, oral testimony, and answers to written interrogatories, and 3, institute civil actions in the courts for injunctive or declaratory relief, damages, costs, and reasonable attorney's fees. Remedies and resolutions of such actions must include timelines for their completion, and the local agency must come into compliance within the time period. The Attorney General may seek damages for failure to reach compliance within the specified time. At the initiation of an investigation, the Attorney General must confer with the local agency at issue, the United States Department of Justice, and the Office of Independent Investigations. In any investigation or action against a local agency that is subject to an active investigation by the Department of Justice, the Attorney General must not seek any relief or remedies that conflict with the federal action. The bill provides that in the discretion of the court, the Attorney General may recover the costs of the action, including reasonable attorney fees, if the Attorney General prevails. Additionally, the bill provides that by September 1st, 2026, the Attorney General must develop and publish a model policy for law enforcement agency accountability systems. The policy must meet certain requirements established in the bill, and in developing the policy, the Attorney General must consult with specified entities and individuals. The bill also provides public employers subject to the Act may not enter into or renew collective bargaining agreements that conflict with the Act, nor may any local or state law, rule, or regulation conflict with the Act, except those that effectuate a previously adopted collective bargaining agreement for the duration of its term. Finally, the bill contains an emergency clause and takes immediate effect. That concludes my remarks. Happy to address any questions.
We have a question by Representative Burnett. Sorry.
Thank you, Chair Taylor. Yes, I'm just curious. In the briefing here, it says that local law enforcement agency does not include the Washington State Patrol or any other agency, department, or division of the state government. Can you advise who currently investigates those Constitution violations and how that will be handled through this bill?
Representative, to clarify, your question is if there's any current authority to investigate the Washington State Patrol for constitutional violations?
All right, if there are no further questions of staff, Vice Chair Farivar.
Thank you so much, Madam Chair, Mr. Ranking Member. I am excited to bring you House Bill 1056 and specifically the proposed substitute bill that passed out of Senate Law and Justice. Really appreciate the opportunity to have this hearing. This is a bill of absolute critical importance. So over the years, Washington has unfortunately seen many instances of law enforcement misconduct. Some have been at the individual level, some have been at the department level, and from Auburn to Clark County, we've seen complaints that have gone unanswered at the Department of Justice. We've seen patterns of excessive force emerge, and we've also seen quite serious mistreatment and neglect in our jails as well. You may know that Washington is 4th in the country for jail deaths. We've done really good work developing mechanisms to hold individual officers accountable, but we don't have a clear mechanism to look at the system as a whole and to look at the culture of some of these police departments. Right now, we rely on the United States Department of Justice to do this work, but they're responsible for the entire country, and I don't know about you, but that seems to be a pretty unreasonable scope of work to me. Just a few weeks ago, the Department of Justice also announced that they are going to be freezing all civil rights cases, and that includes police investigations, which means that their already difficult scope of work is going to just be non-existent anymore. We should all be alarmed by this change. If we can't rely on the federal government to show up and do those investigations, then we need to be able to take care of ourselves. We've got many different laws that require our law enforcement to enforce the laws. They impact immigration, they impact reproductive health, domestic violence protection orders, our gun responsibility laws, public health measures, you name it. We rely on them to uphold the law. At the end of the day, we don't want to continue seeing this phrase that unfortunately seems prevalent, which is that culture eats policy for lunch. We want to make sure that those policies are upheld. We want to make sure that there is a route for accountability that doesn't solely rely on litigation, but provides tools to address issues early on and at a lower level outside of court. I appreciate the opportunity to bring you this bill, and I'm happy to answer any questions. Madam Chair, may I respond to the question from Representative Burnett? Assuming that you were going to ask that question of me, Representative. The reason that the State Patrol has been exempted out of this bill is specifically for a conflict of interest issue, as the Attorney General's office also represents them. Nothing prohibits the State Patrol from being subject to the Department of Justice when they decide to pick up these cases again and being investigated from that avenue. So they are still subject to the federal administration's investigations, just not here at the state level.
Thank you, Madam Chair. Yeah, so just a follow-up question for that. I mean, obviously, the Office of Independent Investigations was set up with the concept and the practice of accountability at a local level, transparency, and making sure that there was clear and evidence of making sure that there was, I guess, an accountability side of things. But this seems to be a double standard when we don't address it in the bill, specifically to say who's going to handle those complaints and investigations for DOC, correction side of things, to DCYF. And again, because what we're saying at the local level through OII, Office of Independent Investigations, is that we need an outside independent review of these, but doesn't that set a double standard for the state itself without addressing it to say specifically who's going to handle that? Because this isn't going to just happen on a local level. This could happen statewide. So I don't think that's fair for anybody to say that it's only a county and a municipal issue. This is a statewide thing. That you just said it yourself, that Washington State is number 4 in the nation. So we should be looking at this, I guess, across the state to see how do we address it in the totality of it. I'm not against accountability. I think it's an amazing thing, and integrity, and it makes everybody better, and especially those good agencies and those good leaders. They want to see this happen. So thank you.
I appreciate the question, and I'd be happy to continue talking about this offline. What I will highlight here, I don't personally see it as a double standard because there is a federal office that is able to pursue those investigations. While there might be challenges in the immediate future on those investigations actually being pursued, there is that availability there. For the Office of Independent Investigations, our very own Representative Entenman actually worked on this legislation, and it is very explicitly and specifically for individual circumstances where there might be an officer that maybe once has engaged in excessive use of force. That's what the Office of Independent Investigations is set up for. It is not ready or prepared to do a very different type of investigation, which would be the systemic questions here. I'm really happy to talk offline to see if there's a way to clarify that and address your concerns.
Question? Representative Graham.
Thank you, Madam Chair. So, in considering this legislation, we've already seen a few times, I think 4 to be exact, where officers have gone through multiple investigations and then been subject to this exact type situation where they were found innocent. And there's lawsuits, now that the state is facing? What sort of side guards are there to make sure that this is not going to be abused, and who is overseeing these investigations in the event that there is trouble or a conflict of interest?
Thank you for the question. So I want to make clear again that I'm not sure about the particular situations that you're speaking of, Representative, but from the way that you phrased it, it sounds like you're talking about individual officers. And this legislation is not aiming to look at individual officers, but to look at, for example, departments as a whole. I just want to make sure that that's really clear here. I understand how that might be possibly confusing given the previous work that we've done. The Attorney General's office will be the one doing these investigations, and they're actually going to be testifying today in a little bit, and I think that would be a great question to ask them in terms of what their accountability oversight structure looks like as well.
Okay. Representative Walsh.
Thank you, Madam Chair. Rep. Farvar, one question in 3 parts. First of all, does this proposal match the federal guideline currently, which requires a pattern of behavior, or could this apply to a single episode of questionable behavior? Secondly, is there any reasonable and likely appeal process to the Attorney General's rather open-ended ability to investigate these matters? And then thirdly, to your point about culture eating policy, does this really do anything to improve the current culture of law enforcement in our state, in which people are loath to get into the line of work of law enforcement because of a series of state laws and guidelines that make that work very difficult to do well?
Okay, let me see if I can recount each one of those questions. I believe the first question was on making sure that this addresses a pattern rather than one instance. I believe those clarifications are in this legislation to ensure that it is a pattern that we're looking at here. Was there a second part to that first question?
An appeal or adversarial response to the Attorney General's proposed open-ended investigatory authority?
That's a good question. I don't actually know the answer to that. I don't want to misspeak. I wonder if staff might be able to answer that question.
Just to clarify, the question is whether there's an appellate process to review the Attorney General.
Correct, or whether that could be structured as an adversarial to start with. Either way.
The bill doesn't provide anything specific on an appellate process, but in the nature of bringing a legal action, they'd be subject to judicial review. So if the Attorney General files an action in court, the parties are going to be subject to the adversarial process, including appellate review of those decisions.
Thank you. That addresses it in part. I just want to get it earlier in the process, but that does answer the question. Thank you. And the last one on culture eating policy.
Yes, I do think that this will be an important measure to put in place to address culture as well. One of the things, well, I think it'll be important to put in place because at the end of the day, while I'm certainly hearing, just as you are, that folks do not want to go into the profession, I think there's a number of reasons why folks don't want to go into the profession. I think that having a clear accountability mechanism in place to make sure that individuals who are there to do good work are able to continue doing that good work and not have it interrupted or have it be influenced by negative environmental factors, what have you. I do think that this will be an important measure to put in place to address that. If I can offer another piece of information for your previous question, one of the things that this legislation does that I think is of really critical importance is it provides a number of tools for the Attorney General's office to address this, again, outside of court, before it gets into the legal system. So they are required to send notice to the law enforcement department to make sure that that they know that this is happening, that a conversation can happen. It gives them a lot of different tools, which, again, I'm hopeful that you'll be able to hear from the Attorney General's office afterwards on, but that we are trying to do as much as we can to address this outside of court.
Thank you. And we will move into public testimony. Thank you so much for bringing this bill, Representative Farvar. First up will be Shelley Washington. We'll have Malu Chavez and Curtis Robinson.
Good afternoon.
Please proceed.
My name is Malu Chavez. I serve as Executive Director at Northwest Immigrant Rights Project, and I'm here testifying in strong support of HB 1056, an important bill that establishes a pre-litigation process for the Attorney General's office to obtain information and attempt resolution for alleged violations of Washington state laws or the Constitution. It adds critical tools to the Attorney General's existing authority for civil actions. Through the work of Northwest Immigrant Rights Project and providing legal services across the state, we often come across situations where community members have experienced violations of their civil rights, such as when a law enforcement agency fails to comply with the law. And in such situations, Northwest Immigrant Rights can and does file lawsuits on behalf of the individual clients to defend their rights. There are times, however, when someone has brought up this concern and we know of a pattern of agency violations and an unwillingness to comply with the law, but there are also egregious situations where it could either be to investigate, for the Attorney General to have that tool to investigate that egregious situation and determine whether it's a systemic issue. So to answer Representative Walsh's question, both the pattern, but also the egregious situation is possible. It would be important for the AG's office to have these tools to come in and ask for clarifying information, attempt to get compliance, and if necessary, proceed to court. And the goal is to get local law enforcement agencies and jails to follow existing laws. This will be important to protect all community members, including people with who lack immigration status. Thank you.
Thank you. We're going to, no questions of any of the panels. We're going to proceed, and we're going to go down to a minute so we can get as many testifiers as possible.
Thank you.
Next up.
I see Shelley Washington online. Go ahead, Shelley.
Good morning, Chair Taylor and members of the committee. My name is Shelley Washington. I am testifying pro on behalf of the Washington Coalition for Police Accountability. You will hear today from others that this legislation is not needed. You might even hear that the police don't engage in misconduct. I couldn't disagree more. I have experienced the systems at play here. My nephew, Kevin Peterson Jr., was killed by Clark County deputies October 29th of 2020. Kevin isn't the only victim of Clark County Sheriff's Office and Vancouver Police Department. The data shows a pattern of using excessive force against people of color, Pacific Islanders, and those with mental health disorders. In Vancouver, use of force against Black community members is 5 times higher than their representation in the population. In November 2021, due to the history of excessive force, the Vancouver NAACP and ACLU requested the U.S. Department of Justice investigate these patterns. Haven't heard a thing, crickets. This is why I'm here, to ask the state legislator to step in add subpoenas powers so the AG can investigate and sit down with local agencies and jails and prevent the harm from continuing. This legislation will get police departments and jails in compliance with laws that are on the books, laws that you passed. Otherwise, who are we going to call when the agency culture is the problem? Thank you.
Thank you. Next testifier. And please note that we're at 1 minute instead of 90 seconds.
Yes, ma'am. Thank you, Chair, Vice Chair, Ranking Member, Committee, and sponsors. I'm Curtis Robinson, Spokane, Washington, 99202, with the Washington Coalition for Police Accountability, and I did the time. I am here in support of HB 1056. And a clear examination shows that racial disparities exist in policing and grossly impact harmful incarcerated outcomes. Most of the countless back and forth about whether this is a reality is truly just a feint to keep these egregious, racialized, and harmful dynamics ongoing. Instead of getting any amount of pushback from law enforcement or jails, they should be the first ones at the table saying, hey, how can we help? How can you help us do better? HB 1056 is not only designed to help prevent such future harms, it sets forth the much-needed accountability mechanisms for when expectations and sworn commitments of law enforcement agencies and jails to follow through on the law doesn't happen. It provides a framework to help get that more in alignment. And one of the things I believe is true integrity invites transparency and seeks out accountability. I urge you to support this legislation and further accomplish meeting those outcomes. Thank you.
Thank you for your brevity. Vice Chair Farivar.
Thank you, Madam Chair. We'll hear from Eliana Manshevsky, and then we'll go to an in-person panel of James McMahon and Candace Bach, followed by Michael Transu. Go ahead, Eliana.
Thank you. Good afternoon, Madam Chair and members of the committee. My name is Eliana Machevsky, and I am a staff attorney at the National Police Accountability Project. We strongly support substitute HB 1056, which would provide critical tools to remedy and prevent violations of Washingtonian statutory and constitutional rights. We are a nonprofit organization dedicated to holding law enforcement and corrections agencies accountable. We have 550 attorney members who litigate law enforcement misconduct in Washington state and throughout the country. Our clients often face various procedural barriers to challenging agency level issues with department policies, practices, and customs that tolerate or sanction misconduct. And so we know that it is so important for an independent agency to be able to investigate and litigate these department-wide issues. We urge you to vote this out of committee, and thank you for your time.
Thank you. Next up.
We'll hear from our in-person panel of James McMahon, Candace Bach, and then Michael Transu. On deck, we'll hear from Robin Emmons, Shalia Stallings, and Kelly McConney-Moore.
Good morning, Madam Chair. Members of the committee, for the record, my name is Michael Transu, and I'm here today representing the Washington Fraternal Order of Police. And I'm going to be brief, given 60 seconds. We support the proposed substitute 1056 because it is not intended to address isolated acts of misconduct or to hold individual officers liable for misconduct, but rather seeks to engage law enforcement agencies in consistent quality policing and agency accountability. We think it recognizes that substitute Senate Bill 5051, which you all adopted in 2021, is a place where individual officers can be and are held accountable for their improper actions or misconduct. It focuses on law enforcement agencies where there can be insufficient accountability systems, training, and policies that lead to inappropriate patterns or practices. And it requires coordination with the U.S. Department of Justice and requires the Attorney General to confer with the DOJ and the Washington Office of Independent Investigations to ensure that resources are being properly used and that there is no conflict of interest out there with the DOJ or OII investigations. Thank you, Madam Chair. Happy to answer any questions.
Thank you. Candace?
Let James wrap up. I'm Candace Bach. Thank you, Chair, members of the committee. Candace Bach, representing the Association of Washington Cities, here in opposition to this proposal. We've heard that this is clarifying the Attorney General's ability to take action. We do think that the Attorney General has the tools to take action when they believe there's a pattern or practice. What this bill does is grant pre-litigation subpoena power to the Attorney General's office to make inquiries, request records, and conduct interviews. We're concerned that that could create interference with ongoing internal investigations. If, say, the Attorney General's office were to grant immunity to an officer, then they couldn't be held accountable other ways. We think that the 10 FTE that the fiscal note indicates the Attorney General's office would hire to carry out this work indicates that they're going to do this in a wide swath, and that could take a lot of resources away from our public safety departments in trying to respond to our community needs. Finally, the language in there about bargaining, we think puts us between a rock and a hard place when it comes to binding interest arbitration and not being able to enter into a bargaining agreement. So I'll stop there. The red light's on, but we do think that's a conflict. Thank you.
Thank you.
Good afternoon, Madam Chair, members of the committee. I'm James McMahon, Policy Director with the Association of Sheriffs and Police Chiefs, here to testify opposed to this bill. We think fundamentally the state should be helping us, not suing us. The Washington Attorney General is substantially different than the United States Attorney General. They share the same name, but very, very different roles there. Ironically, we think the $3.7 million state agency fiscal note would hire more than a dozen law enforcement officers and is a better investment of those resources. We also wonder whether the insufficient accountability systems referenced in this bill would include circumstances where a state arbitrator requires a law enforcement agency to reinstate a fired officer, and then we would also then be sued by the state for complying with state orders. We have been, frankly, under the spotlight for years, and frankly, rightfully so. Our law enforcement agencies were asked about 4 years ago what we're going to do if the federal government comes to take their guns. We told our constituents, we're controlled locally. We're not a federal and we're not a state law enforcement agency. We're controlled by the voters of this jurisdiction. Today, when we get asked, are you going to help round up all of the persons of color in our communities? We tell them we're not controlled by the federal government. We're not controlled by the state government. We're controlled by those in our communities. We don't know whether that remains true under the provisions of this bill. We ask that you help us serve the members of the public rather than suing us.
All right, thank you so much. If there's further comments, you can, of course, email the committee. Representative Farivar.
Thank you, Madam Chair. We'll hear from Robin Emmons and Shalia Stallings Alima and Kelly Connie Moore.
Good morning, Chair and members of the committee. My name is Robin Emmons. I'm a criminal defense attorney from Yakima. I'm testifying on behalf of the Washington Association of Criminal Defense Lawyers and the Washington Defender Association in support of SB 5066. This bill is healthy for communities struggling with a lack of trust between law enforcement and corrections, and civilians on the other hand. Current practices for investigating wrongdoing vary wildly across the state, geographically and over time, as leadership changes and budgets fluctuate. There is also tremendous pressure put on local investigators who are asked to take a critical look at their peers when misconduct is alleged. There is an understandable instinct to protect brothers and sisters in uniform. I feel it, and my job is to criticize them much of the time. This comes with resistance to outside scrutiny, despite the fact that law enforcement should have nothing to hide. Both police and the folks who are entrusted with our jailed community members have a sacred trust to care for the lives of the vulnerable as they seek to enforce order. When that trust is violated, statewide consistency in responding to allegations of misconduct can do much to soothe the turmoil that results, especially in smaller communities such as mine. Thank you for your time today and for your service to the state of Washington.
Thank you. Next up, Shalia.
Good afternoon, Chair Taylor and esteemed members of the committee. I'm Shalia Stallings Ilima, testifying in support of the proposed substitute bill on behalf of the Washington State Attorney General's office. I'm an Assistant Attorney General in the AG's Civil Rights Division. I've been with Civil Rights since 2016. Our work there is civil law enforcement. We enforce the law when there has been more than one violation or when a practice has capacity of harming multiple members of a Washington community. This bill would provide tools for us to use and follow up on allegations that significant or widespread misconduct is occurring at a department. The bill clarifies existing authority, but also importantly gives us tools that will allow us to more effectively serve our Washingtonians. Because we know from experience, pre-suit investigations allow us to avoid litigation, reach agreed resolutions where changes are warranted, and close matters when no enforcement is necessary because there's been no violation of law. Our expectation is that this will be guardrails to ensure that departments are not violating the law, but that these will not be everyday occurrences. Thank you for the opportunity to testify. I'm happy to answer any questions.
Thank you. Next up.
Thank you, Madam Chair. We'll hear from Kelly McConney Moore and Ryan Lufkin.
Chair Taylor and committee members, my name is Kelly McConney Moore. I'm the Deputy Director of Legislation at the Policing Project, and I'm here in support of the proposed substitute. You've already heard about how important the pre-litigation tools are, so I will focus on the importance of this bill, especially right now. Presently, it's particularly critical that the Washington Attorney General's civil rights authority be clarified and strengthened. Even under the best circumstances, the federal DOJ cannot address all agencies with a pattern or practice of constitutional violations. And as the prime sponsor noted, currently all new civil rights investigations are halted, making it more important than ever. There's also a definite local need for the Attorney General to have clear power with flexible tools to investigate civil rights violations. The Seattle Times reports that from 2017 through 2022, Washington cities and counties paid over $100 million to resolve lawsuits arising from allegations of police misconduct, indicating at least some systemic issues. We believe that with this bill, Washington can make significant strides in public safety and high-quality policing across the state. We support HB 1056 and urge this committee to recommend passage. Thank you.
Thank you. And our last testifier.
Yes, Madam Chair, we have Ryan Lufkin.
Chair and members of the committee, my name is Ryan Lufkin, and I speak today on behalf of the Washington Council of Police and Sheriffs in opposition to the bill. By way of background, I'm a practicing attorney and was a prosecutor in Multnomah County for over a decade. To be clear to some of the questions that have come up, the text of the bill does not require anything systemic. A single violation somewhere would be sufficient to start a ruinously expensive lawsuit. The bill also eviscerates the rights of police to engage in collective bargaining. It authorizes the court to fashion orders that violate collective bargaining as relief to anything that the Attorney General sees as leading to a single violation of law that started the investigation. I hope everyone here would consider themselves friends of organized labor, and yet here is a bill that completely destroys collective bargaining, but only, of course, if you put on a uniform and a badge. Finally, the bill will result in local jurisdictions simply conceding out of fear of ruinous cost. Only the Attorney General can win their fees if they win. For some reason, there isn't a competing provision that allows the locality to win their fees if they win. That is a stacked deck. This bill will not result in a fair proceeding or a careful consideration of anything. The end result will just be local police being thrown under the bus to avoid the unbelievable costs that this bill would bring. We ask you to reject the bill. Thank you.
And with that, that will conclude the hearing on House Bill 1056, and we will adjourn for the day for the Civil Rights and Judiciary Committee for February 11th, 2025. Thank you.